there is quite a range. Sometimes a case can be abortive in nature. It's filed, but it's clear that the case has no hope of success, and shortly thereafter the court dismisses the case. So that can be very, very short-lived. On the other hand, it can stretch out for many, many years, depending on whether or not the creditors accept that sort of treatment. Generally, in an individual bankruptcy case, we have things last for 3 to 5 years. In fact, Subchapter 5, which is for small businesses, and as I said earlier, is available to individuals who own small businesses, requires that the debtor make payments equal to the disposable monthly income for 3 years, and that can be extended to 5 years. So in individual cases, generally we're looking at something on the order of 5 years, unless the creditor accepts some longer time period. And sometimes that's important. I just got a Chapter 11 plan confirmed in which there was a debt that was just too large for the debtor to be able to pay in a 5-year period. So it's been stretched out in that particular case to 7 years. But with secured debts, those can be restructured and spread out over a long period of time. As a matter of fact, in that same case, there is a secured creditor holding a note on a particular piece of real property, and that creditor's note got restructured so that it's stretched out over 30 years. There is, of course, the issue in an individual case of whether or not the debtor is going to live. I mean, if a 75-year-old debtor files for Chapter 11 protection and wants to restructure a debt to last for 20 years, the court may be somewhat reluctant to confirm that plan unless, of course, the creditors don't go along with it, for the obvious reason that the debtor might not be around to make those payments. But the long and short of it is a Chapter 11 plan can last really almost any time. There's a lot of flexibility there. Now, sometimes you'll have a Chapter 11 plan that is a partial liquidation plan. And in that partial liquidation, the debtor proposes the plan, and in the plan, there is a provision that says the way the plan is going to be funded is through the liquidation of a particular asset. And so if everybody gets on board with that, liquidate the asset in the bankruptcy court, there's an auction, and sometimes those auctions can really be quite lively. And then the creditors are paid out of that liquidated asset, and that's the end of it. You might wonder, well, why wouldn't we just sell it before we went into bankruptcy? Well, part of the problem there is there may be a foreclosure proceeding against that asset, and the debtor needs time to be able to get that thing sold. And in a Chapter 7, the Chapter 7 trustee would simply seize the assets, and the debtor isn't going to get that benefit. And in a Chapter 13, well, the debtor might not have, might have too much in the way of debt to qualify for Chapter 13. So a Chapter 11 partial liquidation can be very useful in that context. And that would be a short-lived Chapter 11 plan.